Hey everyone, so today we are going to discuss a situation when a plaintiff in a hostile courtroom alone. So first of all, imagine the silence when your client just steps into a courtroom alone. So no friendly coworkers at your side, and just a wall of a corporate witness poised to deny everything. And this he said, she said standoff is notoriously brutal, as investigators know that such he said, she said cases occur when two parties just give a different accounts about what happened and there is no independent witnesses. And the courtroom can feel like a dark alley, just where only the defendant's shadow stands against her. And even without a friendly witnesses, every case has hidden angles with strategy, so those very shadows can be turned into your allies. First of all, you should gather every shadow or evidence. When open-eyed witnesses just are absent, unfortunately, so hunt down unseen evidence. Think like an investigator, so combine through text logs, emails, calendars, just security tapes and swipe card records for any hint of something or communications. And as experts explain that hidden sources of evidence may be born, so call logs, emails, and contemporaneous notes, photos, videos, or voice memos, swipe access cards, so everything can happen. So, and for example, a beige swipe log might place the harasser outside, so the restroom just before the incident, and an email just read the timestamp just can nail down the timeline. And even if your client's private notes or a diary written that night of an incident can be powerful if just properly admitted. So always ask, what data, digital or handwritten, did the company generate? And even HR investigation records or a meeting notes, so often so just protected, are usually just discoverable in employment cases. And just don't overlook doctor's notes or therapy reports documenting just stress or trauma, as they corroborate your story with the real-world consequences. Of course, if it comes to the hidden digital trails, like a phone, pull phone and computer logs, as a telephone or a Slack timestamps can fix just who was there, when, and emails often contain a metadata, so sender, time, hidden, read, recipients, and that expose just silences or pips. Security and the page data also available. So if you request security camera footage or building access records, swipe cards, logs, so may show your accused boss just pacing the hallway or just lingering in a risky area at the crucial moment. Of course, internal investigation files as subpoena and just any resources or security notes. So, but remember, so all investigator notes are likely discoverable when there is a legal claim, and those internal, just blind interviews could hide the other side, just fear or contradictions. And by systematically leaving no stone unturned, you may find an email or a photograph just that makes a witness or often an inanimate object. So and just every fact you pin down tightens and the nose of the defense. Of course, you can and you should so use discovery aggressively. As a skilled plaintiff lawyer expects the defense to stonewall, so counterattack hard, demand full threads and drafts, and if the defense produces alone just a mail snippet, supervisor just question to HR with no answer, immediately requires a request of the conversation. So don't let them just hang you a puzzle piece without a picture. And if counsel claims that's all we have, so serve a new, highly specific request for let's say, all prior and subsequent messages relating to this topic. And the law even lets you insist on the ECI in a native format with metadata intact, so hidden edits or deleted drafts emerge. You should demand drafts and versions, the final ones from all performance reviews or termination letters, just as it's often sanitized, but don't accept only the polished end products. You should subpoena just every draft and revision And those earlier drafts can be gold. So they sometimes include stray of comments or removed language, just them revealing bias. And as one just veteran notes, a deleted comment in a draft that might just reference attendance issues or even just use a sexist stereotype just clues your jury needs. You can force me to evidence, of course, so inquire just about other employees. And if your client insists, so she wasn't the only target, so push for a records or a testimony of just any coworker who complained or of similar treatment. And defense lawyers often resist this Me Too or comparator requests, but don't let it up. So file motions to compel if necessary. Prove that a supervisor skewed younger men, but let just everyone else slide. For example, so can light the path for jurors. And when you press on the paper trail, so sometimes just nothing is more telling than what's missing. In one case, in Lexington with Gap, so the employer just swore if it fired the plaintiff for many customer complaints. Yet at the trial, so Gap produced no contemporaries, just written documentation of any employer complaints. And despite testimony that it abides just by rigorous just record-keeping policies. And the Fifth Circuit let the jury infer so that the story was made up and highlight just any such holes. Your Honor, so they told us they document everything. So where are the papers of this case? And in practice, so when you dig deeper and never just settle for the first no or the first set of 500 emails, so the defense just grudgingly coughs up and just makes them sweat for every bit of evidence and motion to compel, of course, but you should always put in subpoena for metadata and threaten sanctions, and if they fake a compliance, so all are just fair to play an aggressive game, and you should use all the methods. So if it can help you at least somehow, at least turn hostility just into gold. And the depositions is the next step. So let's discuss this another one advantage that you can use during discovery if you have no witnesses. As depositions become your laboratory just to break bad witnesses. Employment side, so defense side, HR, so it's all a hostile witness category. So you should be very careful with them. And if a defense witness just sneers and refuses to help, so that hostility can actually work in your favor. As one litigator observed that a witness dripped with contempt, but his contempt made him careless. So his answers often contain gold for fodder for a subsequent just cross-examination. And when a hostile witness can condense and you really just think that it's important, so those kinds of questions. So and you remain cool and just press on their brick loose. And most important things that you should always just be mindful about is the preparation and keeping cool and control. So go in just knowing the key documents and admissions you need and stick to an outline. So be polite, even sympathetic on the record. It makes the hostile remarks just stand out just more vividly. And don't argue on the record. Instead, just use tone and control. And if they filibuster, so you ask that already, I'm done. Politely ask the reporter to read the question back and insist on an answer. And repeating it again and again forces them to answer. You can use their emotion against them. A combative just witness often just gives away just more than a timid one. And one lawyer notes that when his adversarial witnesses just became annoyed, I think I eventually just convinced them that the fastest way out just of the room was to answer my questions. And his contempt made him careless. And in other words, so angry rambling can expose contradictions or frustration under pressure. It's obvious. So let them just pollutantly try to wear you down, and you will get those stranger just truth on the tape. You can be as a good guy, so maintaining a calm, just courteous demeanor, just even when the other side is sneering. So the record should show you're professional, Then later the jury sees she was a calm plaintiff versus shrill defendant witnesses, and the contrast helps. Remember that witness hostility can work to your advantage if it makes the witness more loquacious and just expensive. And in short, so they ramble, you catch them. There are many trigger questions that you can also use in your advantage. So if a hostile witness, let's say, calms up, so try a simple, just factual prompt. Do you recall where you were on June 12th? And sometimes just concrete can break their stance. And if that fails, so move on the circle back later. And of course, sometimes asking about a collateral topic will loosen them up. So above all, so don't get angry back, and your focus is the transcript. And one just won't subpoena that the witness just feelings, but jurors see facial expressions, and just hearing hostility can bias them. So let their defense lawyers just get hated instead. You just keep calmly just marking the answers, and beating adversarial in deposition is not just the end of the word. It's often the beginning of their downfall. And every evasive just twitch or slip is a weapon for your opening statement. You can call the enemy troops and adverse witnesses into your arsenal, of course. So there are many surprising tricks that many attorneys overlook. So you are allowed to call a person who from the other side camp and just question them first. And in federal practice and many states, if your client calls an adversarial party, so say a corporate witness or a former manager, you get to start with a cross-examination, and in effect, you lead your own witness. And if you identify potential adversaries, just look at the defense roster. If a high-top just executive or a supervisor just could be an important witness, and just either force the defense to list them or just prepare to subpoena them yourself. And the rule is if the other side will not just call the person, you can, so and you can get to cross-examine first. That's also just a leverage. Subpoena as a strategic tool. So if you know a key witness is just, for example, a boss who allegedly denied knowing about harassment, so isn't on the witness list, so ask opposing counsel just if they will call him, and if not, send a trial subpoena at least 10 days before a trial. So since that person is aligned with the defense, so the courtroom procedure flips. So you can start the cross-examining them, which is normally the phase of a greatest advantage. And cross first, then just own it. When you lead an adverse witness, use short, appointed questions, so you demand yes or no answers whenever possible, and you turn any prior statements that made into a trap. So for instance, if the HR director once told investigators just nothing happened, so get that record and ask her to explain line by line, leading just questions like, isn't it true you told HR on October 1st that client never reported any harassment? So force her to publicly just commit to or contradict. And when you're exposing their flaws in the plain sight, just as one strategy guide notes that juries are more likely to question their liability and of the defendant's entire case if they witness that the defendant is engaging in contradictions. You can imagine that the boss face, as you read along, just aloud his internal email where he laughed about ignoring complaints. And under your cross, he is no polite to witness, but a trapped figure. And by the end, the jurors' doubt will have shifted. So they saw your witness, a hostile one, and caught him in a lie or two. And calling the enemy's people and just treating them as adversaries hands you the initiative. And a hostile adversary just trying to spin a story under your lead is like a fire in the darkness. So it reveals everything around it. By the end, or during the trial, which is the most important part, so you can weave all these standards into one powerful story in opening and in closing, and make the jurors feel the emptiness and just your client faced. So emphasize that the only witness to the misconduct were her frantic phone calls. So they backed up files, so her shredded meeting notes, and ultimately, so her own voice and credibility. You should highlight silence and as evidence. If the employer claims it documents all complaints, ask rhetorically just where is the paperwork? And just lack of any just written complaint when policies just say they shouldn't exist, become evidence as a cover-up. And the gap case shows that the jurors can infer no documentation equals a cover story, and ask the jury, so why would a meticulous company suddenly go blank? When you emphasize inconsistency, so when the defense witness just testimony, so they may contradict each other or just earlier statements, and point out each flip. If a manager switch told just EOC one reason and then tells another to in the courts, so say which story do we believe? And the court's long ego held that weakness in implausibilities and inconsistencies, and in the employer's just proffered reasons, and that all can let the jurors find discrimination. So you should build a team and underscore comparators. So when you describe any imbalance, so did other men with similar complaints get off scot-free? And a classic rule is that different treatment of similarly situated employees is a strong proof of pretext. And if a male coworker just lied about quality control and kept his job, so ask why isn't he on trial? So use any just Me Too stories and performance data to argue. And the boss made an example of your client for reasons he never admitted. When you humanize your client, so at just every turn, so remind the jury who is paying the price, and details the harassment just traumatized her, and how every promotion and a paycheck was ripped away. And she may be the sole just star on the stage now, but she is not weak, and she is a brave just protagonist. And you are now asking for a pity. You're showing a strength and just in her fight, and from the podium. So don't flinch at the lack of witnesses. So spin it as her strength. So say they have countless employees. So she has the truth. And use analogs that resonate, and maybe just compare the juror to the guardians of justice and search a dark forest as evidence, just for one lost child, the truth. And be dramatic, so even if darkness, a single light can lead the way, and your tenacity will signal jurors that hiding behind the silence wouldn't let the defendants escape unscathed. And a fictional courtroom clash, it's just illustrative, so we can imagine one, so just to see the tactics in action. Imagine, for example, a scene. So the plaintiff, Maria, once suffered workplace assault by her supervisor, and no one else saw it. HR closed her case for just inconclusive, and a trial. So Maria's lawyer paints a vivid picture that Maria alone in a cold office, and her phone locked in her hand after an incident, and her eyes is bleeding for help, and that never came. And on the stand came the defendant witness, and first is the HR manager, Miss Turnell, and just pleasant face and firm. So our records show only one complaint, and it was investigated, she stated. And the lawyer just flips your file. Oops, no report exists. So by your rigorous rules, there should be paperwork from me, but there isn't. And Turner's blow furrows, and jurors see her skull, so they lean in. Next, so the supervisor, adverse witness, sits. So because he works for the company, and counsel start with a cross. Sir, you testified under oath that and you see that Maria never complained, correct? And as a hostile witness, he snaps. Yes, that's right. And the lawyer presses. Yet your own emails from that week call her a liar. So how do you reconcile that? And the room groans tense, and he sputters and just avoids eye contact. And under gentle persistence, he contradicts earlier statements, and each denial creates a doubt, and that bubble the jury remembers. And at any point, just during Maria's turn, so the defense attacks, she has no proof, no one was there, and the lawyer just raises a hand calmly, and we have a lot of proof, he replies. He plays a hidden video clip, just taken from a building security camera, and in flow, the supervisor just pacing outside the Maria's office that night, long after his shift ended, and the jury just murmurs. And there were no witnesses in the hallway, and the lawyer notes softly that, but here is one, the camera. And finally, so during closing, the lawyer kneels at Maria's just empty chair, and look at what has happened to her. Just sleepless night, therapy bills, and this day in the court alone, he says, and he looks directly at the jurors. So if your story had been false, so wouldn't the company have just thrown every document and person at us? And instead, they present a silence and a stone, and then he lists the evidence and the text from a co-worker's complaints of the record, and unanswered emails and page swipe-up logs, and one by one, so he pins each clue to the wall like trophies. And by the end, jurors see Maria's truth just reflected in the broken pieces, and they understand that though alone, so she brought the facts into the light. And winning without friendly witnesses is of course it's a possible. Yeah, it's not always feasible. So it's a fight in a dark battlefield, but with a diligence and a cunning. So the plaintiff side can turn just even a shadow against the adversary, and by exploiting every oddity, so in the defense story, and every scrap of hidden evidence, you gave the jury no choice but to find the one brave voice in the courtroom, your client.